Yes, Mr. Hancock.
My Lords, can I start off by answering my Lord Justice Males's question in relation to what happened to Eli Lilly?
Oh, yes.
The Lordship will find on the desk in front of you a judgment of the Court of Justice. The Court of Justice dismissed the reference on the ground that it was hypothetical, and that the three reasons that have been given by the judge for making the reference were ill-founded. But rather than taking your Lordships through it, perhaps I can, it's a very short judgment, perhaps I can simply leave it with your Lordships to read.
Yes, all right. Thank you very much for finding that out. And presumably it never went anywhere in this court. As far
I
as
don't
you've
believe
been
so,
able
my
to
Lord,
trace. No.
I was then going to turn to the case of Cartesio, which is tab 38, bundle 3 of the authorities bundles. And there actually, this is the authority relied upon by Spain in its skeleton argument in relation to the jurisdiction of the Court of Appeal and the limitations on the jurisdiction of the Court of Appeal to overturn decisions of the lower court. And here actually, if I can ask your Lordship to start by going to paragraph 4 of the judgment, which sets out the various questions that were referred to the Court of Justice. The relevant one for present purposes is the third of those questions. Does a national measure, which in accordance with domestic law confers a right to appeal against an order making a reference to a preliminary ruling?
Sorry, where are you reading from?
Paragraph 4, my Lord, which is page 359.
Oh, the Advocate General. Right.
It's in the Advocate General's, my Lord, not the judgment. I do apologise.
Yep, no, I've got it now, thank you.
So you will see there the question there is, does a national measure, which in accordance with domestic law confers a right to bring an appeal against an order making a reference to a preliminary ruling, limit the power of the Hungarian courts to refer questions for a preliminary ruling, or could it limit their power, derived directly from Article 234 EC, if in appeal proceedings the National Superior Court may amend the order, render the request for a preliminary ruling inoperative, and order the court which issued the order for reference to resume the national proceedings which had been suspended. And Article 234 was the predecessor article. This question was dealt with by the Court of Justice at paragraphs 88 to 98 of the judgment, which are to be found at paragraphs at pages 383 to 384 of the report. Again, in light of the length of the extract, if I can just ask your Lordships to read through that 10 paragraph.
Yes.
So just going through those paragraphs briefly, what is clear firstly, in particular from paragraph 89, is that the court was upholding the principle laid down in Rheinmühlen number 2, that is to say that the procedures available under national law remained available. Secondly, in paragraphs 90 to 91, then the court noted that the system was based upon a dialogue between one court and the other, the national court and the European court, the initiation of which depends entirely upon the national court's assessment as to whether a reference is necessary and appropriate. Thirdly, the court noted that in Hungary, then an appeal could be made against a decision-making reference to the court for a preliminary ruling, whilst the main proceedings remains pending in their entirety. So, under Hungarian law, the appellate court had power to vary the decision to refer. Fourthly, the court reiterated what it already said at 88 and 91, namely that the decision on appeal could not preclude the lower court from making a reference, and the lower court could not be bound by principles of precedent to follow the higher court's decision. That's paragraphs 93 to 94. Fifthly, that the court went on at paragraph 95 to 96 and 98 in the summary of the earlier part, to say that in accordance with those various principles, the appeal court could not exercise national law rules to set aside or vary the order for reference. Rather, it would be for the referring court to draw the appropriate or proper inferences from a judgment delivered on an appeal against its order and come to a conclusion as to whether it was appropriate to maintain the reference for a preliminary ruling, amend it, or withdraw it. And that's paragraphs 95 and 96, as summarised in 98. So overall, then, I would submit that this case makes clear that, firstly, there is a right of appeal to the Court of Appeal. So, as a matter of jurisdiction, this court has jurisdiction to entertain an appeal. However, secondly, then the real relevance of Cartesio is in relation to the remedies which are open to the appeal court on such an appeal. So the appeal court cannot overturn the decision of the referring court. It is for the referring court to decide, in the light of the decision of the higher court, what are the appropriate inferences to draw from that decision, and whether or not it should maintain or revoke the reference that it has made. Spain, for its part, suggests that the decision in Cartesio goes further than that. As we understand it, then Spain's argument is as follows. Firstly, Cartesio provides that appeal courts can issue judgments in relation to decisions by lower courts to refer only where national procedure permits the higher court to issue a non-binding advisory judgment. And secondly, by virtue of the doctrine of stare decisis, the Court of Appeal in this country cannot issue such decisions because of the fact that the lower court is bound by the decision of the higher court by virtue of that doctrine. We would submit that that is looking at matters entirely through the wrong end of the telescope, and that what Cartesio is saying is it's saying that the doctrine of stare decisis in the context of questions of interpretation of the EU treaty must be treated as amended so that the lower court cannot be held to be bound in relation to such a question. By such a question, I mean a question of interpretation of the EU treaty, because at the end of the day, it is for the lower referring court to decide for itself as to whether or not a reference is justified. That does not detract from the ability of the Court of Appeal to express its views as to the correctness or otherwise of the decision to refer, leaving it to the lower court in the normal course, and I'll come back to why I say in the normal course in answer to my Lord Justice Males's question from just before lunch, leaving it open to the lower court in the normal case prior to Brexit to decide what the appropriate inferences to be drawn from the higher court's judgment are, and whether whether the reference should be maintained in the light of the Court of Appeal's conclusions.
I just understand what you're saying. You're saying that the appeal is argued, the court then gives a judgment on what?
The court sets out its views, it can only be its views, as to whether the decision of the lower court was correct or not. And the difference is that whereas in the normal course, and by that I mean actually in relation to stare decisis as it stands normally, the lower court would be bound by the decision of the higher court.
Well, there's no decision at the moment. We're not talking about a decision. We're just talking about giving a judgment, not an order.
Yes.
So it just expresses what it would do.
Yes.
Or what its view would be if it could overturn this.
Yes, we'll come back to the exact remedy, but it could, for example, take an analogy from arbitration, but it could remit to the lower court the question of whether or not the reference should be maintained in the light of the court.
What's the power to remit?
Well, the power to remit is in CPR. CPR 5222B.
Oh no, but that's refer any claim for determination, not remit a claim for redetermination. I mean, I don't see on the face of it how, unless the lower court's decision is quashed, set aside, the lower court has any jurisdiction to reopen its own decision.
It's given
functus, isn't it?
Well, it's given such jurisdiction by virtue of the Court of Appeal's order to remit, in the same way as in relation to arbitration.
Well, you're going to have to give me some help as to where that appears in 5020, because the lower court has already determined the issue.
Yeah.
So there's no question of referring the claim for determination. It would have to be referred for reconsideration. But that is not one of the Court of Appeal's powers, as I read it.
I would submit it is.
Well, have you got any authority for that? The court can just simply say to a lower court judge, try again.
Yes, I would submit actually that clearly falls within the wording, refer any claim or issue for determination by the lower court. So the appeal court, it essentially, by definition, the matter is being before a lower court because it wouldn't be before the appeal court otherwise. The next stage.
Well, look at the notes that they deal with it. MVF3 and Besnet. The judge concluded, this is Arnold, concluded that it's not immediately obvious that it empowered the Court of Appeal to direct the lower court to reconsider an issue it had already decided. The practical approach was to assume that in essence the Court of Appeal's order required the judge to reconsider its conclusion on a particular question of fact, and that the order should be taken to have been set aside, and any issuer's stoppel. Set aside any issuer's stoppel. And that's the problem, isn't it? Unless we set aside the order, it's been determined. And there's no basis for that judge or any other judge to reconsider it.
Well, there's no such thing with respect as a first instance judge being functus in circumstances where the Court of Appeal can send the matter back to the first instance judge.
I know, but that's what this is considering. Whether whether this is that power.
Well, I would submit that it plainly is, because as I say, by definition, 1, there has been an appeal. 2, the Court of Appeal has reached a conclusion on something, which 3 renders it necessary for the lower court to make a determination on the issue. The issue being, in this instance,
well, Mr. Haggart, you can assert it plainly is. My difficulty is I don't see how it arises, because the way as I understand it works is a decision at first instance is a complete and binding decision as far as it goes, unless and until it is disturbed. I quite agree we could set it, if we set aside the decision, we could then remit that point to be decided afresh. But whilst that is an extant, undisturbed order, nothing we were to say in a judgment, absent an order, would disturb it as a binding decision of the judge. And I don't see how we could cloak the judge with jurisdiction to re-decide a point he's already decided.
And there's a trap here too, isn't there? Because if we set aside the order, then the judge, if he wants there to be a reference, has got to make an order for a reference, which no longer exists.
Yes.
You can't do that.
That's exactly the point I was going to come back to in due course, because that's one of the points that arises in relation to your Lordship's question to me just before lunch. That in relation to the question of whether a second reference, if you like, is possible, if the Lordships were with me that the first reference should not have been made at the time that it was made, that in those circumstances a second reference would no longer be possible. And the combination of the finding, firstly, that reference number 1 was made at a time which was premature and therefore wrongful, and 2, reference number 2 is no longer possible, the end result is that the reference would need to be set aside.
There's an important distinction between whether there would be jurisdiction to do that or whether it would be right to do it. If this court can't set aside and
Yes.
merely remits, the reference remains in existence, there remains an order for reference, and the decision for the judge is whether to maintain an existing reference, which the judge has power to do, but you would say, for the reasons you've been describing, it would be quite wrong
Yes.
for him to do. But conversely, if we can only remit having set aside, then it does become a jurisdictional question. It's perfectly straightforward. The judge can't make a second reference. So it matters, doesn't it, whether the relief is set aside and then remit, or remit, quite apart from my Lord Justice Phillips' point about whether there's jurisdiction just to remit without setting aside.
Well, we would have to be remitting in the sense of not asking him to not asking the judge to make a determination, but to make a determination as at retrospectively, because otherwise he couldn't do it. If we said now, determine the issue now, so it would have to be asking to reconsider as at the date he made the original decision.
Yes, but then the answer to that, my Lord, would be you'd have to reconsider by reference to the correct principles, by reference to the date on which the original reference was made. And if as at the original date that the reference was made, it wasn't right to make it.
That's a novel concept, isn't it? Because when normally when a matter is referred back, it's done fresh, isn't it?
Yes, it's a novel concept, but it's a novel concept which arises in unique circumstances, because the rules of the game have changed in between the moment when the first determination is made and the moment when it's
So the judge would have to put out of his mind that he subsequently determined the human rights point against you.
Yes.
But is that right? I'm trying to think of other analogous situations where one might have a remission in relation to the exercise of a discretion. Let's take a jurisdiction case, for example. And suppose the judge decides a jurisdiction dispute on a legal basis, which the Court of Appeal on Appeal decides is the wrong legal basis. And the Court of Appeal says this isn't one of those cases where we're in a position. Perhaps, let's say, there's been some oral evidence. We're not ourselves in a position. We're going to send it back for him to exercise his discretion afresh on the basis of what we have now said are the correct legal principles. I'm inclined to think that in those circumstances, the judge does then exercise his discretion by reference to the circumstances as they subsequently exist. I mean, in jurisdiction cases, one sometimes gets the example where what's happening in foreign proceedings is of importance, and what has subsequently happened casts a very different light on the discretionary factor.
Yes.
So that wouldn't be sending it back for the decision to be exercised in the notional situation in which the judge then was when he first exercised it. It would be exercise it in the present circumstance.
The difficulty, obviously, in our case, is that the jurisdiction no longer exists as at the date that it is remitted back to the...
Well, the jurisdiction does exist because he's made the reference, and he does have jurisdiction not to revoke the reference that's already been made. I quite understand you say that would be
wrong.
A wrong exercise of his discretion.
Yes.
But we're on the logically anterior question of what if we're remitting,
Yes.
we're asking the judge to do.
Well, your lordship, it must be right that your lordship is asking the judge on that hypothesis to exercise his own discretion in the light of the views expressed by your lordships as to the correct approach to the exercise of discretion.
Yes, and in the light of the fact that he now has decided that the human rights point doesn't succeed, and in the light of the fact that there is, in fact, a reference which he has made, whether rightly or wrongly, and now being asked whether, in the current circumstances, it would be necessary to maintain it or revoke it. Would that be the approach?
Let me take it in stages, Lord. My starting point, what I was dealing with here, was the question of whether the Court of Appeal has any jurisdiction. And my answer to that would be clearly yes. There isn't a case which suggests that the Court of Appeal has no jurisdiction. Indeed, all of the cases show that the Court of Appeal does have jurisdiction.
Understand. You say can't set aside, but can remit without setting aside.
And then that's the second point.
So in a way, we don't have jurisdiction to set it aside. Is that right?
Yes.
That's what you're saying.
Yes.
The second point is my Lord Justice Phillips's point. It is if one doesn't have jurisdiction to set it aside, you have jurisdiction to do something, because as a matter of European law, the cases say that such remedies as exist in domestic law remain available to
But that's the power to set aside, isn't it?
Well, no, because European cases say, well, or perhaps more appropriately, what the European cases say is, this is what Cartesio says, they say, well, you can send it back, but the first instance court is not bound by the decision of the...
It's not bound not to refer.
It's not bound not to refer, and it's not bound actually by anything that the Court of Appeal or the higher court says in relation to the decision as to whether or not to refer.
I wonder if you're conceding too much from Cartesio. It seems to me that I'm not sure that it is saying that the Court of Appeal cannot set aside the reference. It seems to me it's saying that it can set aside the reference. Isn't that the effect of 89 92 and 94. And they refer to the fact that under Hungarian law,
Yes.
there's power to set aside the reference. And they nowhere say that the Hungarian court can't do so. In fact, it seems to me they quite plainly say the Hungarian court can do so.
Well, it may be that that's the effect of 97. That the existing reference must have its full effect so long as it's not been revoked or amended by the referring court. Such revocation or amendment being matters on which that court, i.e. the referring court alone, is
Yes,
able to make a decision.
The court in 97 obviously is a reference to the European court. And so the...
Now, I'm on the last two lines of 97.
As I understand it, what that paragraph is saying is that unless and until the reference is actually revoked or amended by the referring court, it being for the referring court alone to take that decision,
Yes.
then the CJEU carries on with that reference because it is an outstanding reference still. But so,
And it couldn't do that if the order for the reference has been set aside.
No.
That's how you're interpreting
Yes.
Cartesia.
yes. So, my Lord Justice Phillips may be right that one's perhaps conceding too much by saying that the proposition in Cartesio that the lower court is not bound by the higher court's decision operates so as to mean that the lower court can't actually vary or revoke the lower court's decision.
Well, isn't it helpful to look at paragraph 89, where a few lines down, so nevertheless, in the interests of clarity and legal certainty, the court, that is the ECJ,
Yeah.
must abide by the decision to refer by the lower court. So, what I understand this is saying is, look, the national court can do what it likes, but the ECJ retains jurisdiction.
Yes. I mean, effectively, as
To-
I understand it, the way in which it works is that step one, the referring court makes a reference. Step two, once that reference has been made, until it is revoked or amended,
Yes.
the ECJ retains jurisdiction in
So-
relation to the reference.
So Mr. Justice Butcher makes the reference, we hear the appeal and set that aside,
Yeah,
but that is written water
yeah,
unless and until Mr. Justice Butcher reads our judgment and says, whoops, I shouldn't have done that. I accept what it said, I withdraw the reference.
yes.
Now, whether or not it is how he approaches our judgment, seems to me, it is not a matter we're concerned with at the moment. But the fact that there can be an appeal, we can set aside, but that the reference nevertheless continues, it seems to me it all appears quite clearly from this.
I'm certainly happy to accept that, my Lord. But as I say, the case was cited for the proposition that the Court of Appeal lacks jurisdiction to hear an appeal and do anything about
No,
matters.
my lord, that's not quite where we put it. We don't say you lack jurisdiction to hear it. It lacks jurisdiction to set aside the reference, which is a different thing.
Well, whether we set aside Mr. Justice Butcher's order, what is clear is that the reference, nevertheless, as a European process, continues.
Yes, and what's also clear is that it is for Mr. Justice Butcher
Yes, but there's
to
no difficulty.
determine whether or not to revoke.
Then there's no difficulty about any of this. Is that we hear the appeal, we do or we don't set it aside, and then if we do set it aside, Mr. Justice Butcher then has to decide whether to withdraw.
Yes. The only caveat to that, which goes back to the point my Lord Justice Mayles asked me just before lunch, is, and this may or may not be a matter for this court, but if the position is that this court takes the view that Mr. Justice Butcher, in the now changed circumstances, could no longer properly maintain a reference because of the fact that he could not make a reference as at the date of the remission to him, then this court could deal with the point simply as a matter of practicality.
You've lost me there.
So starting point is what your lordship's just put to me, which is that in the final analysis, if this court sets aside the order of Mr. Justice Butcher and refers the matter back to Mr. Justice Butcher, it's then a matter for him to decide as to whether or not to maintain or revoke the reference. And in the meantime, the reference will be continuing before the CJEU, because once it's started, then the CJEU retains jurisdiction until it is revoked or amended. The further question that then arises is, how does Brexit impact upon that question? That's to say, in circumstances in which the remission to Mr. Justice Butcher would be being made at a time when Mr. Justice Butcher no longer had a power to make a reference, does that impact upon his question, his discretion as to whether or not to maintain the existing reference, and if so, how?
I don't think we do. I don't think we do remit it back to him. I think all we do is we set it aside. We give our judgment. We set it aside. It's a matter for him if he wants to.
Yeah, well, it would have to be brought back in front of him in order for him to decide whether or not to maintain the reference.
That doesn't need to be. That doesn't require us to do anything, does it? No doubt, you would then make an application to have the matter listed before Mr. Justice Butcher for.
Yes.
Well, I mean, I think we have got to explore some of these things. Otherwise, we're in danger of making an order which leads to a nonsense. What I mean, we set aside the order. How does it then get back before Mr. Justice Butcher if we don't remit it to him? He's funked us. He's decided it. Under what principle can it come back before him? And if it does come back before him, is he entitled, as a matter of European law, to say, well, I don't really care what the Court of Appeal have said. I think it is necessary. So I'm not going, leaving aside my Lord Justice Popplewell's point about changed circumstances. He could say, well, I think it was necessary back in December 2020 when I made it, so I'm not going to do anything. And then the reference proceeds, and you may or may not take part in it, but no doubt Spain will be explaining why their side of the case ought to prevail. And the European Court in due course gives a judgment. Well, is that then binding on the English court? Because it arises from a reference which was made in time, but which the Court of Appeal has said ought not to have been made, but nevertheless it has been made and it continues. I mean, we're in a very Alice in Wonderland world.
Well, as a matter of practicality, Lord, I would submit that if your lordships were to set aside the order of Mr. Justice Butcher, it would have, as a matter of practicality, to go back in front of Mr. Justice Butcher, whether your lordships brought it back before him or my clients brought it back before him on an application for him to revoke the reference that he had made. One way or another, the matter would have to come back before Mr. Justice Butcher. Under all of the European case law, then the final decision as to whether or not to maintain the reference or make a new reference would be for the referring court.
But if we set aside the reference, his order making the reference, and directed that an issue be referred to Mr. Justice Butcher as to whether or not the reference should therefore be revoked, that would encompass it, wouldn't it?
Yes. And the point I was making earlier on is simply that the further question that would arise in front of your lordships is, well, is the right way to do it, as it were, to send it back to Mr. Justice Butcher and say, right, we've told you what we think about the reference that you made way back when, just before the withdrawal date. In the light of that, now please consider whether or not you wish to maintain that reference, and it will be for him to decide whether or not to do so. The second alternative.
Is there an appeal against his decision?
To make a reference.
Well, it's whatever he decides.
You mean, is there an appeal against his decision
I mean, he's making an order
Yes.
on this basis, and usually there is a possibility of applying for permission to appeal against an order.
Yes.
Does that apply in this case?
Yes, I would say it must. Because effectively, he would just be, one would just be in the same situation as one was first time round. He would be being invited to reconsider, in the light of your lordship's judgment, whether that reference should be maintained, and in the normal way, a decision on his part, if he were to decide that the reference should be maintained, well then, no doubt, Spain might well be seeking permission to appeal against that decision. If we were to decide that the reference should be maintained, no doubt my clients might be seeking permission to appeal. But in principle, the answer to your lordship's question, I apprehend, must be yes.
It may be that there would be a jurisdiction to revisit the question as to whether the reference should be revoked. In most normal circumstances, that would be caught by the Channel and Woolworth principle that you can't have another go. But if the intervention of this court involved a judgment which said you got it wrong last time, that would be a sufficient change of circumstance to justify, and it wouldn't be a question of whether he had or lacked jurisdiction to revoke the reference or reconsider it.
No. It would simply be essentially saying that he had exercised his discretion wrongly, and now he would be called upon to exercise his discretion in accordance with the appropriate principles.
Anyway, in a nutshell, your reason for saying that on any second go, however that might happen, he would not be entitled to take account of the fact that it is now necessary, even if it wasn't before. Exactly how do you put that?
Sorry, I'm not sure.
Sorry, that was a rather convoluted question. I'm sorry. The question has been raised whether, if it went back to him, he would be entitled to say, well, even if it wasn't necessary before, it is now because I have now decided the human rights points. You say he wouldn't be entitled to take that into account. Can you just encapsulate the reason why?
The answer, my lord, is that he would no longer have the power to make the reference as at the date that he was considering that question. So
no, I'm assuming that it goes back to him in a way which somehow preserves the existing reference, so the question for him is whether to revoke it.
If it preserves the inconsistent reference and nevertheless, as it were, it is, I'm assuming for these purposes that the court holds that the correct exercise of discretion would have been not to make the...
Well, I mean, let's assume, despite what my lord has said, that there is jurisdiction under Rule 5222B to refer to him the issue whether, in the light of our decision, he should revoke or maintain the reference, and that we were to accept your submission that as and when he made the decision, it was not necessary to have a reference. And that's basically your case. So let's just assume that that's the basis on which it goes back to him.
Yes.
And that the facts are that although it wasn't then, we now know that he has in fact decided the human rights ground against you, so that these EU issues are critical to what his ultimate order on the appeal ought to be.
Yes.
Okay, so on that basis, can he take that into account, and if not, why not?
Well, I would say no, he cannot take it into account because by definition, the rationale for holding that his exercise of discretion was wrongful first time round was that at the time that exercise of discretion took place, he did not and could not know whether or not the human rights ground was well-founded or ill-founded. And secondly, that by the time he concluded that the human rights grounds were ill-founded, he no longer had the power to make the reference. And thirdly, that effectively, putting it colloquially, 0 plus 0 can't equal 1. And so you can't say, well, you couldn't properly have made a reference in December. Now we know that the preconditions for your properly making a reference exist as at May. by which time you no longer had the power to make that reference. So you can't put together an exercise of a power which was wrongly exercised together with an exercise of a power that no longer existed, so as to justify the retention of a reference.
Well, if he decided it on the basis of what happened after the 31st of December, he would effectively be deciding it on effectively making a reference at a time when the power to do so had ceased.
Yes.
Okay, that's very helpful, thank you. Have we done that to death, or is there any more?
The only point I should make is that, again, on the jurisdictional question, then I referred your lordships to the FTI case. And that was the one that, in the Court of Appeal in this country, held that the Court of Appeal did indeed have jurisdiction to overturn the decision of the first instance judge, even though their decision would not be binding upon the decision of the first instance judge. That was the one where Lord Justice Jacobs said, well, no doubt the first instance judge would pay regard to what the Court of Appeal thought.
Yes.
Can I then just give you a couple of references, because I'm conscious of the time. As far as the jurisdictional question again is concerned, there's no suggestion in the textbooks that Cartesio deprives the court of jurisdiction, and one sees that from Burton on Civil Appeals. That's at Authorities Bundle 3, tab 42, paragraphs 7413 and 7603, and Gordon and Moffat on EU law in judicial review, paragraph 4.141, that is at Authorities Bundle 3, tab 43. That just leaves, I think, the IS case, and perhaps the sensible course, given the time, is for me to deal with this case in reply rather than now, having heard how Mr. Young puts it
Yes.
in his submissions. I just check if there's anything else. Just one other matter, my lords, and that is in relation to my Lord Justice Phillips' question as to what was put to the learned judge. And if one goes to the transcript, this is in the core bundle.
Sorry, which bundle?
It's the supplementary core bundle. Supplementary bundle. Tab 9. Let's put the second of the bundles tab.
Yes.
And if you go to page 149, which is page 8 of the transcript, and I made a submission there in answer to Mr. Justice Butcher's comment that he was going to put his cards on the table. And he says the practical question is whether I should make a reference on any point before because the club could succeed in relation to a point unaffected. And my answer to that, my lord, is simply that your lordship shouldn't make a reference because of the fact that your lordship could not be in those circumstances without having reached a concluded view on the human rights argument, could not be sure that it was necessary to refer these matters to the CJEU. If your lordship were with the club on the human rights argument, then these matters would become academic. Then again, at page 173...
I couldn't help reading on a bit. And Mr. Justice Butcher then says, well, I've got to decide these points. And over on page 9 at line 10, having identified that it's used, raised it and said, I have to decide those points. And you say you do.
Yes, but I then go on to say, but the question then is whether it's necessary for you to have a ruling from the CJEU in order to decide those points.
Well, the points he's talking about are the reference points.
Yes, my point was the question is whether you need to make a reference in order to get a ruling from the CJEU.
Quite, but you don't seem to be taking issue with whether the earlier point is whether they're points that need to be decided. Of course, there's a separate point that if they need to be decided, do you need the CJEU's views on them? That's all the Act Clear argument and so on. But it did strike me, and it may be I've misunderstood because I've only looked from where you started on page 8 to where we got on page 9, but it did look to me as though, at least at that stage,
it goes on
you were accepting that
it goes on
was going to
as well.
decide those points.
It wouldn't. If I wrote a judgment which just dealt with the second part of a public policy argument, would that be an adequate way of dealing with this case? It wouldn't in this sense. If you were against the club, you would still need to decide the question of irreconcilable. I said absolutely, if I were with the club on that point, I think it's not unreasonable to think that there would be a likely to appeal and probably respondents' notice, etc., etc. I say quite so, but by that time there would be no question of the reference to the CJEU anyway. But as your lordship said at the outset, we're looking at it as of today's date and asking whether it is necessary for your lordship to refer matters to the CJEU. And then we went on to the Act Clear discussion. And then at page 104, which is at 173 of the transcript,
So sorry, could you give me that page again?
yes, it's page 173 within the bundle, my lord. Page 104 of the transcript.
Thank you.
Going over to 105, and again, rather than me just reading it out to your lordships, if you read 104 and 105. Again, my point was one of timing.
Sorry, Mr. Hancock, I'd gone back to look at the very start of this transcript. Can you just tell me where you've got to now?
Yes, it was page 104 and 105.
Thank you.
Internally.
Anyway, those are the passages you wanted to show us, are they?
They are, my lord, and there's only one other point, with apologies, which is in relation to a question that my Lord Justice Popplewell asked, relating to the Coalstaff case. And it's just, I think, necessary for me to point out that the various cases following Coalstaff that are cited in our skeleton are 2020 cases, and so were decided after the withdrawal date was determined. Indeed, at least one of them was decided the week before Mr. Justice Butcher's decision, and decided that Brexit was not a relevant factor in relation to the question of whether or not to refer.
I haven't myself got the decision you said was going to be added, which was one of Mr. Justice Miles, but that's on its way, is it?
Yes.
Right. Anything else? Stephen, do you want something?
This is the Gallagher decision, which is the one that your lordship is referring to. And I'm told that it's paragraph 82, which is the relevant paragraph.
Yes. Sorry, can I ask you a question, Steve?
Mr. Hancock, I was just looking briefly at the start of the transcript at page 184 of the supplemental bundle. And as I read that, there Mr. Butcher is saying that he's approaching the question. This is at page 2.
Yes.
The end of the transition period is neutral. On the basis of the facts as before me as they are, and I have to make a decision in relation to whether there should be a reference in, as it were, Brexit neutrality. Brexit neutrally.
I'm so sorry, I haven't found the page.
Sorry, it's page 2 of the transcript.
Page 148 of
148 of the
the
supplemental bundle.
Thank you.
And I think at line 8 he says, "So I am where I am. I don't take into account in particular the fact that the transmission period will end on the 31st of December. But I am in the position that I am now as to whether a reference should be made." And then at page 3, line 11, he refers to the practical urgency if I am going to make a reference. What's not clear to me is that if at this stage, was it plain that he was going to give judgment on the 18th?
No, I don't think it was plain that he was going to give judgment.
It was.
But it was plain that he was going to give judgment.
What was your lordship's question?
It just seems to me that the odd thing about this is that what I don't see is, and maybe I'm missing it or misunderstanding, is anyone saying to him, there's absolutely no reason why you should deal with this as a preliminary point before you give your full judgment.
Well, from my perspective, Lord, I simply wasn't looking at it in those terms. I simply wasn't thinking about it as there being an application for a preliminary issue for a reference. The question was whether Spain hadn't applied for the question of reference to be tried as a preliminary issue.
No, but
They hadn't applied for expedition.
you'd had an 8-day trial,
Yes.
and these are the closing submissions. And the judge is going to reserve his judgment. But then it appears that he is proposing to give judgment on just one issue in advance of all the others.
Yes.
That seems, on the face of it, to be a rather remarkable. You've said it's a remarkable thing to do,
Yes.
but nobody seems to have said to it. That's it. Why are you doing this?
Yeah, exactly. We made the application for the preliminary reference, and that application deferred until the hearing before the judge.
And you asked for that. Wasn't it further? That's when you asked for it.
I mean, should we go?
Deputy Final Orders, my recollection, at least, is that nobody was expecting the judge, certainly on my year for my part, to give a judgment of the sort that he did, an extempore judgment, just on the reference, when he did. So the thrust of our argument was, as it is now, that you should be dealing with matters all in one go when you come to give judgment on the totality of the dispute. But the difficulty
But I don't see you saying that in the transcript.
well, that was the whole burden of the submissions I was making to you. You've seen me saying, Lord, that the ground for my resisting the making of a reference is because of the fact he couldn't properly make a reference until he was in a position to deal
But
with
there's a
all
difference
of the
between
issues.
saying you shouldn't make a difference because you may decide the human rights point in my favour and saying you shouldn't even consider whether to make a reference. No, they're two exceptionally different
Yeah.
things. I don't see you saying the latter.
Well, what I said is because of the fact that you may decide in my favour on the human rights
Yes.
case, and because if you do, then it wouldn't be proper to make a reference
Yeah.
until you are in a position to determine whether you are going to find in my favour or not on the human rights.
But you
aspect.
submitted to us today that what the judge was doing was was at a most unorthodox stage of the case,
Yes.
and that he'd accelerated the EU law issues. And I don't see either the word unorthodox or accelerated were deployed before the judge. Maybe we could look them up in the index, but I didn't spot them in the passages I was looking at.
It looks to me as if the judge raises, at any rate, the possibility of giving a judgment solely on the reference point at the end of a long day's argument on the 17th of December, page 149 of the internal transcript. There's then what looks like most of a morning's argument, not specifically on whether he should do that, but just completing the submissions, for most of which time it looks as if Mr. Young is on his feet, presumably replying. And then at the end of Mr. Young's reply, page 51 on tab 10, bundle page 231, he says, right, thank you, Mr. Young, I'll give judgment in relation to the question of reference at 15:15.
Right.
And the question is 15:15 what?
In the afternoon.
But it was
Quarter past
turned out to be
12.
12:15. And he rises and then comes back in and does it. And that's simply what happened. Is that
Yes.
as much as... Yes. Okay.
But forgive me, because of your arguments about the fact that he hadn't determined the human rights point, that must be because you anticipated he would determine the reference before the human rights point.
That was the issue as to whether he should make a reference, and we said no, you shouldn't until you're in a position to deal with all of the points, because until you're in a position to deal with all of the points, you won't know whether it's necessary to make a
Yes.
reference. By definition, therefore, we were saying to him don't make a reference now because you're not in possession of the full facts.
Forgive me, in the course of a trial, one argues lots of points which may be contingent on other points, so that at the end of the day the judge gives judgment on all of them. The argument you were advancing seems to me plainly anticipated that he would give judgment on the reference point without having decided the human rights point, because that was your argument.
Well, the argument I was advancing is that he shouldn't give judgment on the reference points before he was in a position to give judgment on the totality, because he couldn't actually determine properly whether a reference was necessary.
Yeah.
Unless and until he decided the human rights points. That argument of necessity is an argument that he rejected in coming to the conclusion that he should actually give judgment on purely and simply the EU grounds, rather than dealing with matters in what I've termed the normal way, by giving judgment on everything, including judgment on the human rights grounds, which would have enabled him to reach a conclusion as to whether it was necessary to make a reference. Instead of which, he decided that, I would submit it plainly, that was in the light of Brexit, because that's why he made the references to him being in the position that he was in, namely having to cut his cloth according to the circumstances. Those circumstances being that if he was going to make a reference at all, then it was going to have to be before the withdrawal date. So our answer to that, obviously, is, well, you shouldn't actually make a reference just because withdrawal date will circumscribe your ability to do so, because you're not in a position to give proper consideration to whether or not a reference is necessary, and unless and until you've got to the position where you are in a position to give judgment on the totality of the dispute, and you're not going to be by the end of the withdrawal period.
But you didn't know that, did you? You didn't know that he wouldn't give you judgment on everything.
Well, that's, with respect, he clearly did, because in his references to I am where I am, he's sitting there a week, effectively, before the last day of term. The relevant documents had to be with the EU several days before the...
That's the practical.
That's the practicality of it. So, from his perspective, if he was going to make a reference at all, it had to be done several days, as it were, before the end of the withdrawal period to enable the practicalities to be complied with.
No, but I mean, you didn't know that he wasn't going to give judgment on the human rights point.
He clearly wasn't going to have time to give judgment on the human rights point, as indeed he made clear in his judgment.
Yeah, he did. I agree, he did in his judgment.
And given the amount of evidence that he'd heard, both expert and factual, then he plainly wasn't going to be in a position to give judgment on the totality of the issues within the requisite timescale.
Yes, thank you.
Yes. All right, well, thank you very much indeed, Mr. Hancock.
Not at all. Well, I apologise for the fact that I've gone over my extra hour.
Yes, Mr. Young.
May it please your lordship. May I just take you back to Article 267, which is in tab 6 of Bundle 1 of the authorities, because my learned friend has said on a number of occasions in relation to the question of necessity to arrive at a decision. And if I may, I think it's probably helpful just to have in mind Article 267 itself. It's Court of Justice shall have jurisdiction, blah, blah, and then after the two lettered subparagraphs, where such a question is raised before any court. Sorry, my Lord Justice Phillips. I'm afraid my bundle's gone the same way as mine. It's almost impossible to turn the pages.
I've done it, thank you.
Where such a question is raised before any court or tribunal of a member state, that court or tribunal may, if it considers that a decision on the question is necessary to enable it to give judgment, request the court ruling thereon. So the essential criterion is whether the requesting court, and that is Mr. Justice Butcher, not your lordships, consider that a decision on the question which is to be referred is necessary to enable it to give judgment. Not necessarily is necessary to the ultimate resolution of the case, and that is why when one sees what Sir Thomas Bingham said in the Else case about it being substantially determinative, but not necessarily quite the same hard and fast rule that Lord Denning stated in Bulmer and Bollinger. And just without showing you Bulmer and Bollinger, you'll see that the judgment of Lord Justice Stevenson was the one which represented the majority, because Lord Justice Stamp agreed with him very specifically, not the then Master of the Rolls. So it's the question for any referring court, in the position of Mr. Justice Butcher, is it necessary to have a decision that I, Mr. Justice Butcher, make a decision on this question to be referred in order to enable me to give judgment? And for one can just look at the way that my Lord Mr. Justice Butcher put it at paragraph 32, probably, which is page 117. While it is true that the court could, the club could win only by reference to the human rights aspect of Article 34.1, a point which I have not yet decided, and I am not today in a position to decide, following words, it is quite clear to me now that even if that were the decision I reached on that aspect of 34.1 point, I will have to decide and give judgment on the Article 43 point. Now, my learned friend's argument is that that was an legally impossible thing for the learned judge to think. Now, that was what he in fact thought, and we can see at the bottom of paragraph 33, he refers to the possibility of an appeal, and he says, that seems to be a further factor indicating that the point should be regarded by me now as critical to my making a proper decision. So if the learned judge was thinking about making a proper judgment, a proper decision, which I would respectfully submit he plainly was, he thought it was quite clear to him that the questions were necessary to be asked. Now, was that a legally impossible thing for the learned judge to think? I would respectfully submit it wasn't. Your lordships are not in a position to gainsay his opinion. And one has to remember that in the matters of a reference, it is the opinion of the judge who asks the question which carries the day. And there is a host of judgments dealing with this particular point, but I don't know if your lordships have got Cartesio. We can go back to Rheinmühlen. But the critical point is that it is his decision. Now, there's one other critical point. Because the only point that my learned friend, Mr. Hancock, is raising is one of timing. He does not make any other criticism of the learned judge's discretion exercise at all. He doesn't say that it was an impossible thing to think that he couldn't give judgment without these issues. His only complaint is at the time he didn't know whether it was necessary or not. The answer is it was necessary to give a proper judgment. But importantly, timing is something with which the authorities, the European authorities, have something to say. And if you've got Cartesio, which is, I think, in tab 38, paragraph 88, it's a passage that my learned friend asked your lordship to look at, but he did not pause on it. And I'm just going to ask you to pause and reflect upon it, since timing is the critical question. Article 8, paragraph 88, Article 234, now of course 267, gives national courts the right and where appropriate imposes on them the obligation to make a reference for a preliminary ruling as soon as the national court perceives, either of its own motion or at the request of the parties, that the substance of the dispute raises one or more of one of the points referred to in the first paragraph of Article 234. It follows that the national courts, that is Mr. Justice Butcher, effectively, have the widest discretion in referring matters to the court if they consider that a case pending before them raises questions involving the interpretation of provisions of community law. And the court, in that case, referred to Rhine-Mühlen, but it's repeated in a lot of cases post-Rhine-Mühlen. Now, just pause on the words as soon as. As soon as the judge comes to the perception, either of his own motion or on the application of a party, that one of the points referred to is raised as a matter of substance in the dispute as opposed to academically, then he, Mr. Justice Butcher, has the widest discretion. Now, the timing is to be found in the words as soon as. As soon as the judge, at first instance, thinks, hold on a minute, I cannot give judgment, or give the judgment in this case that I would like to give, without these questions being raised, then he is entitled then to make the reference. As soon as. And he has the widest discretion. It's not just a discretion, it's the widest discretion, and not one which should be interfered with. And you can see in the Cartesio case the extent to which national appellate courts cannot interfere with the discretion of the learned judge. So what you are looking at is a case where the learned judge has concluded, as soon as he's concluded, he thinks that I will, in order to give judgment, have to deal with these issues. Is it therefore appropriate to make a reference? And that, if I may respectfully say so, puts the lie to my learned friend's submissions.
But does it follow from what you're saying that if Brexit hadn't intervened and if he had waited and he had given judgment in the club's favour on the human rights point, he would still have been entitled to refer the other matter?
Yes, he would. He would, because of course he could have given judgment on the human rights issue. There would have been an appeal, and that may have been overturned. So there would have been an uncertainty even after he delivered judgment. And he knew that the judgment that he was contemplating, a proper judgment, required the questions to be answered.
But isn't that exactly what Mr. Justice Arnold was found to have done incorrectly in the...
It's the opposite case. He had found that he had already found that other points had been decided, and the Court of Appeal didn't overturn those other points. Therefore, the points on which he sought a reference were absolutely academic. And the Court of Justice held they were absolutely academic, and if they arose in other jurisdictions, then there were other questions. So, if I may respectfully say so, what you're looking at is a judge who arrived at the perception, right or wrong, that it was his perception, that he had to deal with these issues in his judgment, and he had the power as soon as that perception arose. And that was his perception, and it cannot be said that that perception was one which was impossible in law.
But the distinction, which, as I understand it, Mr. Hancock draws, is between issues which the judge may need to deal with, which are all the issues, and issues which may be determinative of the outcome.
Yes.
And it's only the latter which can trigger necessity. And you say that am I understanding your submission, that he's wrong about that, that so long as an issue is one which the judge considers it's necessary to deal with in the course of a judgment,
yes,
that's sufficient.
And that's why I showed you Article 267. But the learned judge clearly, he thought it was quite clear that he would have to deal with these things in his judgment. If one altered the words would have to needs to consider these things in his judgment, then I would respectfully submit the circle is duly completed. So if the question is only one of timing, he arrived at the perception that there needed to be one, needed to be a reference. And so far as the timing is concerned, we, Spain, had issued our application for preliminary issues on the preliminary questions, and they were fixed for the hearing of the total appeal. And it was fixed for 6 days because all of the evidence related to the human rights point. There was, I think, no evidence on any of the other points, or next to no evidence. So the learned judge arrived at the conclusion that the judgment that he would have ultimately to give would involve these issues upon which and he would need to arrive at conclusions, and therefore there was an appropriate reason to refer.
Can we just clarify that the term judgment in 267 doesn't have the same meaning as we would, as when we refer to a judgment of the court, in terms of it isn't referring to reason.
Well, that, if I may respectfully say so, yes, it is. It's referring to a reasoned judgment because the Human Rights Act requires, among other things that the Human Rights Act requires, reasons to be given for judgments of courts of law.
No, I of course appreciate that, but what one needs is to have any point decided in order to make a decision, isn't it? You don't necessarily need to have points decided to enable you to write a beautiful judgment.
To write the judgment, what Mr. Justice Butcher called the proper decision, he knew that in order to write the judgment, or to give a judgment that he thought was appropriate, he would have to deal with these issues, which then were the subject of the reference.
But I think my Lord's point is distinguishing between the two meanings of judgment.
I agree.
In English, you can have a judgment, which is a lot of beautiful reasoning, and you get the decision in the last paragraph. Or you could have, for example, an order that the defendant must pay a certain amount of money to the claimant.
Yes.
And that's a judgment as well, and that's what you would speak of when you enforce a judgment, for example.
Yes. Well,
which is
if you have the latter,
which is Article 267.
Oh, the former, undoubtedly. If you have the latter, Article 267 loses any substance at all. Must be.
No, because in order to decide whether the defendant owes money to the claimant, you might need to decide a lot of points of European law.
Well, exactly. But you don't. If all you're looking at is the order, then there's no necessity at all. It's only when you look at the substance of the dispute before the parties, or before the court, between the parties, that one can see what issues are and what issues are not necessary. And one can see the logical impossibility of my learned friend's position. as follows. There are 3 grounds that his clients proposed for the judgment of the Spanish court not being enforced. One was public policy human rights, one was public policy res judicata, and one was irreconcilable judgment. Ironically, he has to rely upon the meaning, the substantive meaning of judgment, looking at the detail, but that's another matter. Now, any one of which, if decided against Spain, would be conclusive of the appeal. Thus, if one looks at the first one, it's not necessary because the other 2 may be necessary, or may or may not be necessary. If you look at the third one, the other 2 may or may not be necessary. And there can be 2 questions on which he made the reference, as there were, on the res judicata and on the irreconcilable judgments, either one of which would render the other one potentially moot. So as soon as you've got one point, this is my learned friend's case, as soon as you've got one point of any substance at all which may be determinative of a case, of a dispute, then by definition you can never have any other referable necessary points. Because the mere existence of the possibility of that point being determinative extrudes all necessity as a matter of reasoning and as a matter of timing.
Well, take this case. If Justice Butchers in May had decided in favour of the club on the human rights ground, then at that point, Mr. Justice Butcher would not need the answer to the references in order to determine to give judgment.
Well,
he could give judgment then, and the other points would never actually come before him.
But for the fact that he then gave permission to appeal.
Yes.
So that the necessity was still as much as it was.
Oh no, because that would not be necessary for him to give judgment.
Oh, but it would be. If that decision was wrong, it would be necessary for him to give judgment on the other 2 points, on each of the other 2 points, in order properly to give judgment.
Well, surely the point is that would then go off to the Court of Appeal, and those 2 points would then be before the Court of Appeal, not for him.
Yes, but he would necessarily have had to decide them.
Not in order for the outcome, not in order to make the order which he was going to make.
Not necessarily.
In the sense that you've been using the words.
But his perception, and I use the word perception because it's that which is used in Cartesio. His perception was that he would need to deal with those points.
How would he deal with them? Because they're off in Europe.
No, he would deal with them in the light of the answers from Europe.
But when?
After the answers had been given.
Why would he? Because the club at that stage, possibly years before, has succeeded.
Don't forget, my lord, he does have the power to revoke a reference. And that, of course, is in truth, the remedy. That if it becomes apparent that a reference is no longer necessary, then it can be revoked by the national court.
Yes.
And that's the remedy. So if he said, I thought it was necessary in December, but now in May, I think it isn't necessary, then I can revoke. But in fact, the irony of the situation is that in fact in May, he says, there it proves it was necessary because look what I have held on the human rights.
Well, I'm not sure how much that helps you because the fact that it became necessary in May.
No, it didn't become necessary. It's the necessity remained and was all the more apparent.
Well, yes.
I don't say became.
Well, that's the dispute between you and Mr. Hancock.
Yeah, I appreciate that.
I think he would not be able to run this point in May, save the fact that by then there was no ability to make a reference.
Yeah, absolutely. But it is that comes to brings us to the question of how the Court of Appeal should approach this jurisdictionally. And strangely, I'm not terribly far off what my learned friend has been submitting, so that's another matter. But the important point is that his perception was that it was necessary to give judgment. And he did that as soon as he had that perception. And that is precisely what 267 says he, as interpreted by the European Court on many occasions, that's precisely what he is entitled to do. So he is absolutely entitled as a matter of European law back in December to do precisely what he did. It may be that his view of necessity was more in line with what one will call the English judges giving judgment view of necessity than perhaps some others. But it was his national court view that it was necessary to deal with these issues. And it would be, I think each of your lordships at various different intervals today has said it is quite common for judges to give reasons on all issues, because it may very well be that the Court of Appeal will hold that certain issues are or not rightly decided, but others are rightly decided and thus have a particular impact upon the outcome of a case. So it's, if he thought the issues needed to be decided, and you, my lords, are not in a position to gainsay him, you're not in a position to gainsay him as a matter of European law, nor indeed on the material before you. One knows, I only have the impoverished experience of an arbitrator, but your lordships have enormous experience in much more elevated stances. But you have to ask yourselves, at the end of every hearing, do you have a preliminary view? And how often is that preliminary view not your ultimate conclusion? He couldn't say that he had decided it because there were still further written submissions to come in response to the 200 pages. But he must have had a feeling in his gut which aided his perception, and he was in the best possible position to know that, much better than your lordships, with the greatest of respect.
You've said several times that he was entitled to do what he did as a matter of European law.
Yes, I'm going to say he did.
Understood and unpick that. Because as I understood Mr. Hancock's submission, it was Irish Creamery says that the test for necessity is a matter for national law. Mm-hmm. And if you look at our national law, then there's a stream of authority from Bulmer, Shirley, Prudential, and so on, saying it has to be determinative of the outcome or substantially determinative of the outcome. And it seemed to me that the submissions that you've just been making are that that's not what necessity means. It doesn't have to be determinative or substantially determinative of the outcome. It simply has to be something which the judge considers ought to be dealt with as one of the issues that he'll decide.
It's substantially
his judgment.
It's substantially determinative because there are three parallel points. This is the point I made about if there's one point that is unrelated to the EU, however good, bad, or indifferent it may be, that can, if you adopt that analysis, can exclude the necessity of all of the other points, which are plainly going to have to be decided, just because there's this one outlier.
Well, why not? I mean, if there's a decisive point in domestic law, what's the point of going off to Luxembourg?
If there is a decisive point of national law, but of course here we've got just the hypothesis, the hypothetical case that there may be a point of national law. In fact, we know...
You've heard all the evidence and all the argument on it, so he was well placed to make the decision.
He was. He was well placed to know what the outcome of the human rights point was. He wasn't well placed to make a decision because there were still some further written submissions to come in.
Yeah.
But there's a bit of a difference.
Don't we just have to take at face value what he says, which is that he was not in a position to decide?
I wouldn't say.
He doesn't. I mean, he doesn't go on to say, but I've got a feeling that
No,
these EU points are going to turn out to be quite important.
but he said it is quite clear to me. Now, if he was wrong for it to be so clear to him, then so be it. But in my submission, you are not in a position to say what should or should not have been clear to him.
But he says very clearly in his judgment that he accepts that if he finds the human rights point in Mr. Hancock's favour, that will be determinative.
Yeah. Well,
so he recognised.
He recognised that,
and he says that he might do.
Yes, but he still said it is necessary for me to consider these other issues as well.
Yeah.
So I mean, at the end,
but we can't just. And I don't think any of the authorities suggest that the judge's mere say-so that he considers these are necessary is the end of the matter.
It's not the end of the matter, but it is predominantly what European law focuses upon. Because, as we know from Cartesio, an appellate court cannot. Well, we know precisely what it says it can't do. It said it cannot call into question or revoke the reference itself. We'll come back. This deals with the jurisdictional matter, but a court of appeal cannot revoke the reference. It can merely give judgment, enabling the.
I think there's a confusion here, isn't there? What Cartesio recognises is that the domestic appeal process isn't affected, and that's what we are.
Yes, absolutely.
That's what we are. We're the domestic appeal process. So we've got to look at this as on a domestic appeal process. Obviously, looking at the fact that the judge was considering a European court reference.
What you can't do is revoke the reference.
That's a separate question, isn't it?
Well, it's a separate question. Yes, it's a separate question, but it deals with the question that you, my lord, raised. Because there are two stages. There is what you do with the judge's order and what you do with the reference. And whatever you do with the judge's order, you cannot revoke that reference. And the reference will carry on unless and until it is revoked.
Yes. But isn't the first thing, before any question about what the remedy is, the first thing we've got to decide as a matter of a national law appeal is whether, in making the reference, the judge was, according to the appeal test we apply, wrong.
Yes, absolutely right.
That's all we're considering. Is he wrong?
Yes.
And was he wrong?
Was he wrong? Bearing in mind that he has not, it's not just a judicial discretion, but it's a judicial discretion which has been described by the European authorities as being the widest discretion, which may be the wider. So you have to, it's not a question of your lordship's thinking, what would we have done in the learned judge's position? It's, was the learned judge, correct, this is a matter of English domestic law, did the learned judge apply the right principles? And my learned friend does not actually say that he misapplied any of the right principles. All that he actually says is that he applied an additional principle which was related to Brexit.
Well, I think what we do know are the facts. I think the facts on which Mr. Hancock relies are undisputed here, and what the judge did is undisputed.
Yes.
We know that there was an issue which didn't involve EU law, which, if determined in the club's favour, would determine the matter. That's not in dispute.
Well, if rendered in the club's favour, it might determine the matter, subject to appeal.
It would at first instance.
Would at first instance,
Which
yes.
is what,
At first instance,
which
I
is
would
what
agree. Got no problem with that.
Is what 267 is determined.
Yes.
Is concerned with.
Yes, I would agree with that.
So there's no discretionary element there. We know that is the fact, and we have the authorities that look at what is necessary in that context. So I'm not sure why we can't consider whether he was right in saying it was necessary.
Well,
without having
what
to
you
investigate his exercise discretion.
You can ask yourself, did the learned judge apply the wrong principles? And on that, as I say, my learned friend's got no complaint at all. He applies the principles very zealously derived from else. And else principles represent the correct principles. So he did not misidentify the principles. Did he misapply them? No, he didn't. He applied them zealously. He may have arrived at a conclusion which another judge would have differed from, but that's not the same thing at all. The only point that my learned friend is running is that he was improperly affected by the approach of Brexit, and that was an irrelevant consideration. That's the only case on what I'll call the English approach to the exercise of a discretion that my learned friend is complaining about. So you've got to ask yourself, did the judge apply the wrong, identify the wrong principles? No, he didn't, and my learned friend doesn't say he did. Did he apply those principles within the ample ambit of his discretion? Yes, he did. My learned friend doesn't say otherwise. My learned friend's only case is that he applied them and did something a little earlier than he might have done because of the proximity of Brexit. And he said, that is an illegitimate consideration. Now, that raises the question of whether it is in fact illegitimate or whether it is a relevant, a consideration which a judge in his position might lawfully have taken into account. If he knew or he perceived that he would have to arrive at decisions as to the impact of European law, and he thought he would have to, one way or another, and whether the fact that he was not going to be able to get the assistance that he would otherwise have as a result of the impending Brexit and the resulting inability to make the reference. Was that a relevant or an irrelevant consideration in law? If that's what he was actually doing. And I would respectfully submit he says he didn't take it into account.
I mean, I understood the Hancock was putting forward his case on two bases, effectively. One was the stage at which the reference is made, Brexit.
Yeah.
And the second is whether it was necessary.
Yes. Yeah,
So
absolutely right.
There's a different points.
They are different
They're
points.
closely related. But
Well, they aren't different points in this respect, that now the necessity is blindingly obvious after the judgment in May. Now, so the only question is whether, because the learned judge hadn't reached the position of actually publishing his judgment, he could lawfully say that it was necessary to consider these other issues back in December.
It seems to me it's very double-edged for you, because if you say it's now blindingly obvious as of May, the answer to that is yes, but then you couldn't make a reference.
Yeah, no, absolutely. I say it was blindingly obvious that he had to consider the issues before the 31st of December. And the learned judge says he did have to. That's the important point. That was his perception. And all that's happened since then is the fact that, doubtless because he had all of the evidence in mind, and he was significantly unimpressed, it has to be said, with the club's evidence, he would need to spend some time articulating why he was unimpressed.
It seems to me you're speculating illegitimately about that. We just have to take it.
I'm taking it.
Which is that he hadn't decided.
Yes, no, okay.
I mean, we can't suppose that he was pretty sure he was going to find against the club or anything.
No, I'm
he
happy.
doesn't say so.
Yeah. So what he did was he said, I need, in order to give judgment, I need to consider these 3 points. Each of them needs to be considered.
Is that necessity? Yes, it is. The fact that they may, in certain circumstances, turn out not to be decisive of the ultimate outcome is where Sir Thomas Bingham's substantially comes into play, and why the rather more stark view of Lord Denning in Bulmer and Bollinger doesn't apply.
It's my fault. Can I just come back to try and pin down what I understand to be your submissions on necessity by reference to the two different ways in which we use the word judgment. One meaning outcome, the other meaning the narrative reasoning for that outcome. Are both of these your submissions that if you treat judgment as meaning the outcome, then it's sufficient to come within Article 267 if the judge considers that it might be necessary to decide the referred issues in order to determine the outcome, even though he can't at the time say whether it will or will not?
No, I say that he thought that it is necessary. It may be that there may be certain circumstances which will go to undermine that in due course, but it is necessary, was his view.
In order to decide the outcome?
In order to decide the outcome.
Well,
yes.
How could he have reached that conclusion if he hadn't yet decided the human rights point?
Because if he hadn't decided the human rights point, it was necessary to decide all of the points. He had 3 points of equal.
No, well,
I'm sorry to be.
I had understood your submission earlier to be that we're not dealing with outcome where we're here when we're talking about judgment.
Well, you asked me about outcome.
I know I did because I was expecting you to say that actually your case is the second of those that I was identifying. That if we use judgment in the sense of narrative reasoning for the outcome, then it's sufficient to come within Article 267, and this is what the judge was doing, which was saying, I can say now that it is necessary to decide all these issues, including the referred issues, as part of my judgment, meaning judgment in my process of reasoning on the way to the outcome.
Yes, that I certainly do say.
That you do say. But what I'm still unclear about is whether you say the judge was entitled to decide and did decide that it was necessary for the referred issues to be decided at the time he made the reference.
I say that as
in order to determine the outcome.
I say that as well.
But how can he have been in a position to say that if he hadn't yet decided the human rights point?
Because he could say, there are 3 points which it is necessary for me to consider in order to arrive at the outcome, whatever it is.
Yes.
I mean,
surely if he'd asked himself the question, do I need to decide the EU points in order to know whether I allow or dismiss the appeal, his answer would have to be, well, that depends on what I make of the human rights points.
Well, he gives the answer in paragraph 32.
Well, he does, yes. He said, yes, I do need to decide all of the points. It may be that if I ultimately decide the human rights point in favour of the club, then that will alter my perception of the necessity.
Well, he says in terms, whilst it is true that the club could win only by reference to the human rights aspect.
Yes. So he appreciates that. But it's a hypothesis. That's why he had 3 equal points that he needed to consider to arrive at the outcome in the stark sense that my Lord Justice Popplewell put it. Each of them is necessary because they are all raised, and each of them needs to be considered by him. It may be that certain ones, if they are decided in a particular way, will diminish the necessity in terms of the outcome.
Remove it. Not diminish it, remove it.
Yes. Yes, remove it. I'm happy with that, my Lord, yes. It's, as I say, I return to the logical difficulty that if there are three alternatives, or any number of alternatives, one of which is doesn't raise a European point, and may, under certain circumstances, be determinative, then that absolutely precludes, as a matter of jurisdiction, a reference under 267 on any of the others, all of which may be equal or more important in the perception of the learned judge.
If he's dealing with it prospectively before he's actually reached a decision.
Yes, and the whole point of the preliminary reference is that it's part of the dialogue, and this is plain from the European authorities, the dialogue between the national courts and the European court, to try and help the national courts arrive at basically a continent-wide, consistent and coherent result. So if you have a point which is raised as a preliminary issue, which it could very easily be, then you can have it referred as to the European Court, because it is, by definition, a preliminary issue, which may or may not ultimately turn out to be decisive, but which is thought to be decisive. And that's where actually the case, the decision of the European Court from the judgment of Mr. Justice Arnold in Eli Lilly is actually rather revealing in this, because it shows that the European Court has got itself the discretion to render references inadmissible. So the proper mechanism is not for the national courts actually to try and impose their will upon the referring court, but for the necessity to be discerned by the European Court.
What has been happening to this reference since Mr. Justice Butcher's decision?
I am told that a hearing has been fixed. I have been given the date, but it is confidential. I'm sure that... No, I'm not entitled to say any more. It has been fixed, and it is going to be heard unless the reference is revoked by Mr. Justice Butcher and not by anybody else. And who knows, the issue of timing may become, once again, rather problematic. But the hearing has been fixed and it hasn't been declared inadmissible. And the club could have made the application to have it rendered inadmissible by saying it was not necessary in accordance with European criteria.
Would it have to be by Justice Butcher, or would it have to be by a judge of...
No, it's the referring court. That's Mr. Justice Butcher.
I mean, suppose, God forbid, Mr. Justice Butcher fell under a bus. It would go back to a judge of the commercial court.
It would be the commercial court, yes. I suppose that's true under those circumstances.
Or he just ceased to be a judge of that court for some reason.
Well, he could, if he ceased to be a judge of that court, he could always go back and sit at it, as I think Lord Justice Gross did a while ago, and Lord Justice Diplock did famously.
That's the answer for all of us in this case.
Yes. Any two of you could leave. Any one, and you are all necessary, but I can't tell you which one. All I can tell you is, my lord, the reference is continuing, a date has been fixed, and I cannot tell you what that date is because I am not at liberty so to do.
Right.
But, as I say, timing may become important, particularly with Christmas and New Year coming up. It might be very important, but I can say nothing more on that. But the point is that Mr. Justice Butcher, by reference to English criteria, stated and applied the correct principles. What my learned friend is doing is saying that although he stated that Brexit didn't have an impact upon him, somehow it still did when he said it didn't. And if you're going to take Mr. Justice Butcher's word and his judgment as for what he says, as my Lord Justice Mayle said with regard to the point that I made a while ago, then you do the same thing with his comment about Brexit. He put it out of his mind.
I just don't think he says that. I think he says that he put out of his account the position of the Court of Appeal. Where does he say he puts Brexit out of his mind? In the judgment.
Paragraph 52 is the only place where he deals with this, as I think my lord identified. And he refers, of course, to ideally. And what he says at the bottom is, with regard to the Court of Appeal would not be able to make a reference. It says, if that approach is right, it is an additional factor indicating that it is appropriate for me to make a reference now. So he's not saying it was in any way determinative in his making of the reference. He says he cast it out. He says I respectfully submit, he says, I add this, in reaching this conclusion, I have not taken into account as being a factor in favour of making a reference that unless this court make a reference, no appellate court will be able, because of the imminent end of the transition period and the consequences. And that's the point that my Lord Justice Phillips was making, that he's referring to, as it were, the inability of a later court to make a reference. And I understand that entirely. But what he's saying is, he thinks it is necessary for his judgment, a proper judgment, to consider to have these issues raised. And if it's the only way to have them raised and resolved by an authoritative body, then so be it. And that's not in any way giving Brexit any particular impact. He would have arrived at the same conclusion whenever it would have happened, is what he's saying. I would have arrived at the conclusion that it is necessary for my judgment to consider these two issues under Article 34. And that necessity is the same before and after Brexit. But if Brexit is relevant at all, it may be that if I've decided it would be wrong to deprive the Court of Appeal of the right to do that which I think is now necessary. That's his point.
It seems to me what one can take certainly from the transcript, the judge had in mind that in order for this reference to be properly lodged so as to beat the deadline, he would have to give a judgment pretty much immediately.
If he was going to make a reference, then it needed to be done quickly, yes. So that was, as it were, whether he gave his judgment on the 18th of December at 12:15, or the 21st of December at 2:30, or even the 29th of December. If he was going to do it, which he thought it was necessary, then he ought at least to do it at a time when the practicalities of the filing of the reference with the European Court could actually achieve something. That's a matter of fine-tuning of the timing of the judgment as to when it was given, but only so.
But do you accept the point Mr. Hancock makes, which is that in the ordinary course of events, this would not have been the way to do it?
No, absolutely, I wouldn't. Absolutely not. It was raised by way of a preliminary issue. The appropriate time to deal with it is on the application of the preliminary issue for coming on.
I beg pardon for interrupting my learned friend. It wasn't raised on a preliminary issue. The application was purely and simply for a reference. There wasn't any application for the question of the reference to be determined by way of a preliminary issue.
Oh, okay. Right.
Yes, I think we understand that. Thank you.
I'm sorry, my lord.
I think we understand that.
Yes. But the answer is that the judge, either of his own motion or on an application, as soon as he becomes aware of the need, can make a reference. We issued the application, and it was, as a matter of simple administration, brought on at the same time as the hearing of the main appeal. But it could easily have been done by way of an application for a preliminary issue. So your lordship says, it's an unusual way. My learned friend regards it as topsy-turvy. Quite the reverse. If when a judge is hearing a trial and he says, hold on a minute, there are some European law points here, I think I want those European law points deciding because I think they may be necessary, I use the word maybe, they may be necessary for me to consider, and I want them considering now, then that would be an entirely proper way of making the reference. And that's why one sees all of the cases that refer, I mean, Cartesio is one, where the court says, while the case is pending before the national court, the reference goes off. So I would absolutely not say that it was in any way topsy-turvy or an unusual way of doing it. If the judge thinks, I need some help on this, then he's entitled to ask for it as part and parcel of the collaborative structure, in those days anyway, between the EU courts and the national courts. So I would absolutely not. It might be, I would certainly say, it might be possible for the judge to give judgment on everything and then say, and thus I see certain of these points that on which I've laboured long and hard might be improved by a judgment of the court of the European Court. But you ask yourself, well, why not actually ask the European Court first, so as to see whether you have actually, how you approach the labouring of the judgment? I mean,
why not decide the domestic points to see whether it matters?
Yes, and if it matters to him, if he thinks it matters, that's the...
No, the alternative is to ask rhetorically, why don't you decide the domestic matters? Because if you decide them one way, the matters may never arise.
That would be one way of doing it. The question my Lord Justice Phillips put is the normal way of doing it would be to give judgment and then to refer. And I would respectfully suggest that may be a way of doing it, but it's not in any way the normal way of doing it. And I do stress
well,
this.
after you've heard all the argument.
Which he had done. I'm not going to bother to write a judgment, having heard all of these arguments, because I think there's important points of European law that I think need to be resolved so that I can then address this judgment correctly. That's what it came down to.
Well, I think that, the point my lord is making, why not give the judgment on the non-EU point, which you've heard everything on, before you go into the question about whether or not you need help elsewhere?
Yeah, I mean, there are many ways of killing this particular cat. The only particular point was that there is, if I think I need help from the European Court, am I going to cut myself off from that help by spending a long time writing a judgment on something else? Then that's a matter for the judge himself. Is he willfully going to cut himself off from the help that he feels he needs to write the judgment?
Well,
and to decide the case?
Is your best point on this that the judge himself says that it will not matter which way he decides the human rights point? So delaying on his analysis is going to make no difference.
Yes.
That just comes back to the question: is he right in his analysis?
Yes. Not is he right in his analysis, although I would submit he is right, but is he justified as a matter of his discretion in his analysis, which is a rather more generous way of looking at it. But I do say he was right in his analysis. But you've got to ask yourself, did he err in the exercise of his very wide judicial discretion? And on normal English law, national English law principles, on the scrutiny of the exercise of a discretion of a first instance judge, there is absolutely no possible scope for criticising the exercise of this judge's discretion, if I may respectfully say so.
Well, can one not look at paragraph 32 of his judgment and say, when he says, even if that were the decision I reached on that aspect of the Article 34.1 point, i.e. that's the hypothesis of
Yes.
the next point, I will have to decide and give judgment on. And to look at that and say, well, that simply isn't right. On no basis can it properly be said that a judge has to decide and give judgment on other points when the club could win only by reference to the human rights point.
Yes, well, that's just not the view of the proper decision that the learned judge thought he had to
He
give.
may well think that's what he would like to do to answer all the issues, but as a matter of analysis, he didn't have to decide it.
Well,
No.
he therefore had to decide it in terms of the issues which a narrative judgment would address, but not if the test is, do I have to decide it
Well, even then,
in order to reach an outcome?
Even then, because the prospect of being wrong, I mean, this was a judge who knew of these particular parties' enthusiasm for appealing. And he could see that any decision at all that he reached would probably be the subject of an
I
application.
wonder if that's legitimate consideration here, and the fact that domestically we like first instance judges to decide unnecessary points doesn't make them necessary.
No, but it might make them necessary for the judge to give judgment on them, which is a different thing.
Well, I'm not sure.
Well, it's what you think that matters. But
Apparently it's not.
it's what you think that matters at the moment. No, absolutely. As a matter of law, that's absolutely right.
Yeah.
It's what the judge thinks. So are you in a position to say that it was outside any rational exercise of discretion that the judge said that he thought there was a need, and that he was quite clear that it was not possible for a man of Mr. Justice Butcher's well-known limited intellect to be quite clear on a point?
And what we're really saying here is that the judges, the Court of Appeal and judges, at first instance, like there to be decisions on issues which are unnecessary for the decision at first instance, because they might be necessary for the decision in the Court of Appeal. So what you're looking at is what is necessary and what Mr. Justice Butcher must be considering is what is necessary for an appeal court, not what is necessary for the judgment at first instance.
No, it's what's necessary for him to put into his judgment. And this is, I mean, I accept entirely that this is taking an English law view of judgment rather than a European law judgment. But if he thought it was necessary to consider to deal with an issue in his judgment, that's good enough, in my submission. I mean, otherwise, you can never
There's
say...
necessary and there's desirable. It's plainly desirable that the judge should address the major issues.
And if, when he's a judge who writes a judgment in the English atmosphere, it's necessary for him to deal with all points, because he knows that if the Court of Appeal consider it subsequently and overturn him on human rights, if he went the other way on human rights, then it would then be necessary, more obviously necessary.
Just to put the point back to you that was put to Mr. Hancock,
Yes.
that the judge could well say, I find in favour of the club on human rights issues, although it is not necessary for me to make a finding on the other points, in case the matter goes further, I will do so.
Or he could say, I've considered all of these points, and I'm against Spain on all three of them, but two of them are dependent upon European law as to what is a judgment for the purpose of an Article 34 judgment rather than Article 367 judgment.
It would equally have been open to him to say, I decide the case in favour of the club on the human rights grounds, and I'm not going to deal with the EU points. And if that had then come to the Court of Appeal and he'd been reversed on human rights, well, depending on the Constitution, the Court of Appeal might have been a bit irritated, but it could nevertheless have decided the points and, subject to Brexit, could have made its own reference if it thought that was necessary.
Or remitted, perhaps.
Is the human rights decision coming to the Court of Appeal anyway?
I think the learned judge gave permission to appeal, but he extended the time for appealing.
Until after the European.
So it has yet to be. So even now, the learned judge, adopting the very strict approach, analytical approach that my learned friend is adopting, even now the learned judge doesn't know whether it's necessary. That's what he would necessarily say.
No, he knows it's necessary for him to give judgment.
Yes.
Because he knows what he's decided, and what the Court of Appeal might decide doesn't affect that.
That is true, but he thought it was necessary for him anyway.
So the club is waiting to pursue its appeal?
Apparently, yes.
Until after
After today, I think.
No, it's the conclusion of the article.
The conclusion of the article.
Points, however long they may take, I think.
Yes.
Which means
Which it won't be long.
May not be for some time.
If I could help, my lord, then the way that I think it works is that the permission to appeal order in relation to the human rights point contemplates that the totality of the proceedings in the Court of Justice and at first instance, because if the Court of Justice proceedings went on, then the decision of the Court of Justice effectively would then go back to Mr. Justice Butcher, so that Mr. Justice Butcher could give his judgment in the light of the views of the Court of Justice. And so at that stage, then there might be an appeal from the decision of Mr. Justice Butcher on the issues that had gone to the CJEU, and an appeal in relation to the human rights grounds.
Yes. That's my understanding.
My Lord, Lord Justice Phillips made a point about what I'll call the Topsy-Turvy argument. Can I just, in the context of that, can I just show your Lordship what Mrs. Justice Rose said in the Coalstaff case, which is volume 2, tab 22, I think, at page 1072. And it may be important when anyone looks at the Coalstaff case.
Sorry, could you just give me that reference again?
Yes, it's bundle 2 of the authorities, tab 22.
Thank you.
It's Coalstaff superannuation. I mean, this is in the context of my Lord Justice Phillips' point about the normal way of doing it. And I said there isn't a normal way of doing it. It's rather different in the case before Mrs. Justice Rose. If one looks at page 1072, paragraph 25 and 26. And 25 says, Mr. Gammy argues that the trustee has enjoyed rights under the TFEU, which are protected by European Communities Act, and there's a real risk that any further inability of a UK court tribunal to make reference will make it excessively difficult for the trustee to enforce those rights. Trustee's submissions in this application invite me to assume that the arrangements that the government will make for resolving disputes about the interpretation and application of EU law are pending at the date of the UK's exit will be so unsatisfactory that, now this is important, that the tribunal should change its usual practice and accelerate the making of a reference. So there was a usual practice before the tribunal, which was not in the present case. And one sees at the end of 26, she says, 4 lines up, similarly, in my judgment, the triggering of Article 50 does not alter the test which the tribunal has hitherto applied. So the case before her was where there was an established practice as to how you deal with questions.
Well, how often do you see, Mr. Young, at the end of an 8-day trial, the judge giving an extemporary judgment at the end of oral closings on one of the issues?
The reason I haven't encountered it very often, although strangely, I'm not sure an 8-day trial, the reason I haven't encountered it very often is because I don't have that many cases involving European law, and probably won't in the future. But I haven't encountered that many cases where, as soon as the judge perceives it's necessary, then he does so.
But you can't. You're not seriously suggesting that if it wasn't for the Brexit cut-off date, that the judge would have done this. I mean, surely he would have given a reasoned judgment.
No,
reserved judgment in the usual way.
Quite the reverse. I think he might very well have done, because he would know how to go about whether he'd need to spend a lot of time considering irreconcilable judgments and the role of res judicata in English law. He would know whether he needed to do that at all as a result of the European Court decision. I would respectfully suggest that it is the paradigm of the case where the judge might, at the end of a trial, say, I've heard everything, I think these points need to be resolved.
No, but forgive me, even but what he delivered in the end was a judgment on making the references.
Yes.
And a judgment on the human rights issue.
Yes.
What I'm saying is, wouldn't you normally have expected that those would have come together somewhat later?
No, I wouldn't, because there is no norm, is the answer. I would expect a judge who perceives a need to get assistance on points to do so at that time. If, as was the case here, all of the evidence had gone to the human rights, then he might very well wish to deal with that evidence while it was still fresh in his mind. But he wouldn't necessarily have waited. He might just say, I've got two major points on the construction of Article 34, and I need to consider whether there is irreconcilability and whether there is a relevant res judicata, which will be very materially affected by what the European law is on the subject.
So you don't think this was rushing a preliminary reference off?
Absolutely not. It was making a preliminary reference at an appropriate time. The circumstances, the particular circumstances in which he did it because of the imminence of the practicalities ending, didn't alter his analytical approach to the point. I mean, I think one is in great danger of confusing a desire to decide a point before the Brexit guillotine fell, and a desire, having decided the point, to do whatever is necessary to get that point properly determined within the confines of practicality and efficiency. Two quite different things in my submission. I can safely say that I have departed almost entirely from my note of argument to deal with your lordship's interesting questions.
Well, there have been quite a lot of them. I think we have to accept that.
Well, yes. Well, I'm grateful. And I happened to notice in the Times that it was my Lord Justice Mayall's birthday last week, and it's mine.
That's an entirely unnecessary point.
Maybe it's entirely necessary because it's my 68th tomorrow.
Well, I'm sorry that you'll be spending quite a chunk of it, by the look of it, for us. But no
I was
doubt we'll
hoping
make efforts to limit that as much as possible.
Far be it from me to render that which is necessary. But anyway.
Well, how long do you, I mean, seriously, how long do you think you will be?
I'm going
quite a lot of your ground, I suspect.
I think I've actually covered a lot of it, albeit not in accordance with my note. I've been dealing with your lordship's questions.
Yes.
There is the question of jurisdiction. And I'm not sure my learned friend and I are very far apart on that. I don't say you don't have jurisdiction to hear the appeal. There is a question of what orders you can and should make if you otherwise allow the appeal.
Yes. All right. Well, you'll tell us your final position on that in the morning.
Well,
and then subject to that, then what, another half hour or so, or longer than that?
It depends what needs to be said. I think I don't know to what extent you will need to have any of the authorities gone through. I will go through my note of what was said by my learned friend about the authorities. I hope that pretty much everything has already been said.
Right. Well, I can see that unlike the European Court, you're determined not to answer my question. But
no, I'm determined to. I would hope to be no more than an hour and a quarter.
All right, so we'll comfortably finish in the course of
Oh, yes, I thought it was going to be a day and a half, and I'm still sticking.
the day. Yes. All right, well, thank you very much. 10:30.
All right.
Right. Right.
Said Fred.
Sorry?
Said Fred.
Yes. I have to take this wall down. This old wall is